Okay, so this video, I'll be discussing pre-trial. So after arraignment, there will be pre-trial and trial proper. Kaya ang tawag dyan pre-trial kasi ginagawa to before the proper trial. So let us start with the definition of pre-trial. It's a procedural device used prior to trial. Kaya ang tawag dyan pre. No? Pre means prior to trial. To narrow issues to be tried, to secure stipulations as to matters of evidence to be heard, and to take all other steps necessary to aid in disposition of case. So the primary purpose of pre-trial is to aid in the disposition of the case. Ano ibig sabihin yan? Para mapadali yung kaso. No? Yung mga issues na hindi importante sa kaso, i-aalisin na yon. No? Yung mga witness na hindi material sa kaso, tatanggalin na yon. Yung mga ebidensya na hindi material sa kaso, tatanggalin na yon. So, yan yung pre-trial. So, wrap up muna tayo. Ito yung stage of criminal action in the Philippines. So, preparing for the case. Actually, this is filing of complaint, as I've discussed. The offended party or the police officer will file complaint with the prosecutor. Then, the prosecutor will conduct preliminary investigation, which we have already discussed, to determine probable cause. And if there is probable cause, the prosecutor will file information with the court. Then the court is given 10 days to evaluate the information. And if there is probable cause, the court will issue warrant of arrest. And the moment the person is arrested, after the issuance of warrant of arrest, then the case will be set for arraignment. After arraignment, there will be pre-trial. Okay, after pre-trial, there will be trial, then judgment, and of course, the guilty party may appeal and execution of sentence. So, ito yung concern ko ngayon sa inyo, yung pre-trial. The court shall, after arraignment, within 30 days from the date the court acquired jurisdiction over the person accused, unless shorter period is ordered a pre-trial conference. Okay? So, again, kailan itong the court acquired jurisdiction over the person of the accused? Kailan mo makukuha ang jurisdiction over the accused? If mahuli na siya. So, pag ang tao ay nahuli na, yung akusado ay nahuli na, within 30 days, kailangan ma-conduct na yung pre-trial conference. Okay? Or, after arraignment, kailangan makonduct na yung pre-trial conference. Ano ang objective ng pre-trial? Again, the main objective is to achieve expeditious resolution of the case. Expeditious means mapadali. Mabilisan yung kaso. Okay, kasi yung mga issue na hindi importante, tatanggalin na yun. Yung mga witness na hindi material, at saka yung evidence na hindi kailangan, tatanggalin na yun. Okay? So, basically, after arraignment, the prosecutor may file ex parte motion to set the case for pre-trial. So ito, this is a crime of theft, no? And the ex parte motion, yung si ex parte isa lang, isang party lang nag-file ng motion. Ano bang prayer niya? It is respectfully prayed that instant case be immediately set for pre-trial pursuant to Rule 18 of the Rules of Court. Okay? So ano bang pre-trial? Ano ba talaga ang pre-trial, no? Well, ito ay isang pamamaraan na ginaganap bago ang trial proper. Pre-trial ang tawag kasi bago ang trial proper. Upang mapag-usapan, anong pwede pag-usapan ito? Ang posibilidad ng pagkakasundo. Okay? Yung plea bargaining, no? Mag-plea guilty ka na, or lesser offense. Pwede yun. Plea bargaining. Okay? Or settlement of the case, no? Admissions sa mga pangyayari, no? This is stipulation of facts. Stipulate of facts. I-admit mo yung fact. Yan. Paglatag sa mga issue, paglalahad ng ebidensya or marking of evidence, and pag-schedule sa petsa ng hearing. So, ano bang hearing natin? Once a week ba? Twice a month ba? No, depende. So, is pre-trial mandatory? The answer is yes. Pre-trial is mandatory in criminal cases. Nakalagay sa rules. In all criminal cases, cognizable by Sandiganbayan, Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court, the court shall. Ang ginamit natin is shall. When you say shall, it's mandatory. Hindi siya may. Pag may yung ginamit, ano yan, parang optional, no? Pero hindi ito eh. Shall, after arraignment or need 30 days from the date of a court the court acquired jurisdiction over the person of the accused, nahuli. The court acquired jurisdiction over the person of the accused, nahuli siya. Order a pre-trial conference. So, yeah, mandatory yung pre-trial. O, tignan nyo. In Rile, Reyes, Napoles, attend pre-trial conference. Kasi nga, mandatory ang pre-trial ngayon, especially in Sandiganbayan. In relation to pork barrel scam. Now, matters to be considered during pre-trial. Ano bang nangyayari during pre-trial? If you remember, ano bang nangyayari during arraignment? Yung FRA, furnishing of the copies of the information complete, reading of the information complete, and asking him whether he pleads guilty or not guilty. Pero dito sa pre-trial, ang mangyayari dito, ito, plea bargaining. Okay? Plea bargain to lesser offense. No? Pwede pa yan. Stipulation of facts. Okay? Ipa-admit mo yung facts sa kanya para hindi mo na kailangan ng ebidensya. Yan yung stipulation of facts. Inaamin mo ba na yung biktima ito ay shota mo? Yes, Your Honor. That's stipulation of facts. No? Marking of identification of evidence. Like, you mark the evidence. No? This evidence is marked as Exhibit A, Exhibit B, Exhibit C, Exhibit D. Okay? Pag prosecutor ka, pag defense ka naman, Exhibit 1, Exhibit 2, Exhibit 3. No? And waiver objection of admissibility of evidence. Pag naglatad na ng ebidensya ang prosecutor at hindi ka nag-object, yung akusado, di kaya yung abogado niya, it is now waiver. Waiver na yung subjection of admissibility of evidence. Now, example, let's discuss stipulation of facts, marking of evidence, and waiver objection to admissibility of evidence. Example ito, student-teacher, pinatay at ginahasa ng kumano ng kanyang estudyante. Student-teacher, no? Ginahasa at pinatay. Now, ano kaya mga possible evidence dito? Ano mga pieces of evidence natin na kailangan isubmit para makasuhan yung estudyante na yan? Well, complete affidavit. Yan. Affidavit of witnesses, kung meron. Police blotter, kung naka-entry siya. DNA result, kung kinuha ng DNA yung semi ng accused. Medical legal report, para malaman kung may laceration. Autopsy report, para malaman anong cause of death. At saka yung death certificate na nagpapatunay na patay. Kasi nga, ang kaso ito, rape with homicide. So, ito yung waiver objection. Di lahat ng prosecutor, ito yung mga evidence namin. Kung ikaw ang defense, pwede ka mag-object. Kasi pag hindi ka mag-object sa mga nilatag na ebidensya, waiver na yun. It's a waiver. Now, kung walang mag-object, ibang mark na yun. So, example, complete affidavit is Exhibit A. Affidavit is Exhibit B. Okay, police blotter, Exhibit C. DNA result, D. Medical legal report, E. Autopsy report, F. Death certificate, G. Pero hindi sapat na mag-submit ka ng complete affidavit of witnesses, police blotter, o medical legal report, autopsy. Kailangan may mag-sponsor. Kailangan may mag-testify niyan. May mag-validate niyan. So, sino mag-validate o mag-testify sa complete affidavit? Yung mother, pwede yung mother, no? Kung siya yung gumawa ng complete affidavit, yung mother ng biktima. Kasi patay na yung biktima eh. Affidavit of witnesses, of course, yung witness. Siya yung mag-testify sa affidavit niya. Sa police blotter, yung police na gumawa ng blotter. Sa DNA result, yung examiner. Yung gumawa nag-examine sa DNA. Medical legal report, yung doktor na gumawa ng medical legal examination. Sa autopsy report, yung doktor na gumawa ng autopsy. Sa death certificate, hindi pulinarya. No? Ang magsicertify ng death certificate is yung local civil registrar kasi sila yung nag-issue. Okay? Ngayon, so, meron ng markings, meron ng wala ng waiver, wala ng object. Ano ng stipulation of facts? Kasi ito yan. If I am the prosecutor, I will offer, Your Honor, I would like to offer for the defense to admit that this death certificate is genuine and duly executed. Pag in-admit niya ng defense, admitted, Your Honor, itong death certificate ito, genuine, duly executed, hindi ko na kailangang i-present yung local civil registrar. Ang tawag doon, stipulation of facts. Okay? Or another example. Your Honor, I would like to offer for the defense to admit that this police blotter is genuine and duly executed. Sabi ng defense, okay, admitted. So, hindi ko na kailangang i-present yung police na gumawa ng police blotter kasi admitted na yung police blotter. And that is what we call stipulation of facts. Pati ito mag-offer, Your Honor, yung defense naman mag-offer, Your Honor, I would like to offer that the victim here, yung babae at saka yung estudyante ay magkasintahan. Sabi ng prosecutor, admitted, Your Honor. Oh, that's admitted fact. No? That's stipulation of facts. No? Nangyari during arraignment. Ano pa mangyayari during pre-trial? Ano pa mangyayari during pre-trial? It will be modification of order of trial. Okay? Modification of order of trial. If the accused admits the charge but interposes a lawful defense. Ano yung mga lawful defense? Ito yung mga self-defense, defense of stranger, defense of relatives, for fulfillment of duty. For example, in this case, yung controversial case, diba? Binaril ni Police Officer Florendo Siragos. Okay? Anong ginawa ng NBI? NBI files a murder and perjury charges against cops in ex-soldier Ragos death. So, kinasuhan siya ng murder ngayon, saka perjury. Pero, anong posibleng defense? Pwede siyang, sabi ng QCPD PNP spokesperson, self-defense yung ginawa ng police. What if he interpose self-defense or performance of duty? Ang order of trial ay mag-iba. Modification of order of trial. Kasi normally, ang unang mag-present ng evidence, yung prosecutor. Okay? After prosecution resist case, saka yung defense. Pero this time, pag nag-invoke siya ng self-defense, inamin niya yung pagpatay, okay, klaro naman siya yung nakapatay, pero self-defense yung ginawa niya, then pwedeng ma-modify ang order of trial. Okay? Mauna mag-present ang defense ng evidence kaysa prosecutor. So that's what we call the modification of order of trial if the accused admits the charge but interposes a lawful defense. Plea bargaining is the process where the accused and the prosecutor in criminal cases work out mutually satisfactory disposition of case subject to our court approval. So, plea bargaining, ito yung pagbaba ng kaso. Instead of frustrated homicide, less serious physical injury. Instead of rape, acts of business. Instead of murder, homicide na lang. No? So, sa pre-trial, during pre-trial, may mga agreement doon, may pinapag-usapan doon. No? May mga pag-usapan. Ang tawag doon pre-trial agreement. Okay? All agreement and mission made during pre-trial conference shall be reduced into writing, kailangan kasulat, and signed by the accused and the counsel. Anong kasasayan na ito ay yung anuman napag-usapan during pre-trial, ito ay napapaloob sa tinatawag ng pre-trial order. Pre-trial order. After pre-trial conference, pagkatapos ng pre-trial conference, the court shall issue order reciting the actions taken, the facts stipulated, and the evidence marked. Okay? And this will be signed by the accused and the witnesses. No? Okay, Napoles signs pre-trial order. Napoles signs pre-trial order in the Telegraph case to start ruling on February 26. Kasi after pre-trial, then trial proper will follow. Okay, so I think that's the last topic that I'll discuss under pre-trial.